Hello everyone, welcome to this webinar about GDPR. My name is Mark Greer, I'm the head of the CAF American Donor Fund. I know I've interacted with a fair number of people on the webinar today, but if you don't know me, I head up CAF's American Donor Fund, which is our service for dual taxpayers, people paying tax in the UK and in the US. Who want to give to charities around the world. And so in the context of this particular webinar, that's mainly helping donors who are Americans who are based in the UK but wanting to give to educational institutions in the USA. I know that the question of GDPR often comes up with American universities who do fundraise in the EU, so we thought we'd put together this webinar today on what is a very important and topical issue. So we'll just briefly introduce the panel and then we'll get into the real subject matter. So firstly is Oliver Willis, who's a senior associate at BDB Pitmans.
So I'm a lawyer specializing in data protection and commercial contracts. In the course of my work, I provide a lot of advice to non-profit organizations, much of it dealing with international transfer of data and fundraising.
My name's Tim Turner. I'm a trainer and consultant on data protection and related matters. I have a very wide variety of people that I work with, but including charities and not-for-profits. And the focus of my work is the practical issues associated with making this legislation work.
Hi, I'm Fiona Boyer. I'm the Compliance Manager and Data Protection Officer for CAF. I've worked here for 10 years, and GDPR is probably one of the biggest pieces of legislation that's come through in my time here. So I'll talk to you about one of the examples that we would work through.
Thanks everyone. So what we're going to cover today is a little bit about what GDPR is, when it applies, what are the key obligations on institutions in order to make sure that they are complying with GDPR. We're going to talk a bit about what personal data is and how to understand your personal data, a bit about the transparency of what you're doing with data and this topic of legitimate interest, which comes up a lot. Going to talk about online research, wealth screening, that kind of thing, and then some practical examples and solutions. If you'd like to submit questions to the panel, there will be a Q&A towards the end of the session, so you can do that through the webinar, and we'll try and get to as many of those as possible, and if we can't get to them, we'll follow up about those questions afterwards. So firstly, I'm going to hand over to Oliver, who's going to talk through some of the basics of what GDPR is.
Great. So the GDPR, for those who aren't already familiar with it, is a piece of legislation that applies throughout the European Union. And really it's aimed at protecting individuals in terms of how information about them is used, and also giving those individuals more control over that information. A lot of the ideas in the GDPR aren't new. There's been legislation like this that applied in the European Union for many years now, but the GDPR has increased the degree of protection in some areas and also had the effect of sort of really pushing this up the agenda for a lot of organizations. So when would the GDPR apply to organizations outside the EU? Well, there are really two circumstances when that could happen. The first is where an organization outside the EU is using personal data in the context of an establishment of that organization in the EU. Now, establishment is quite a broad concept in European law, but essentially it means having a reasonably solid sort of base for doing business in the EU, whether that's business for profit or not for profit. So, for example, if you are a US educational institution and you've established a campus somewhere in the EU, it's very likely that that campus would qualify as an establishment in the EU. Similarly, if you had an alumni office here, that would also probably qualify as an establishment. The second situation in which the GDPR can apply to organizations outside the EU is if those organizations are using data about people who are physically located in the EU, and that data is being used to offer goods or services to those people, whether that's goods or services for a fee or free goods or services, or if that information is being used to monitor the behavior of those individuals in the EU. So, we've been talking about personal data. It's probably time to stop and just ask what that means. The legislation tells us that personal data is information relating to identified or identifiable living individuals. Now, some sorts of personal data are pretty obvious, for example, a person's name or their address. But because personal data covers information that's about identifiable people, it can also include information from which a person could indirectly be identified. So, for example, if you were collecting information about location through an app, or if you were collecting information about IP addresses or web browsing behavior, and you were doing it in a way that allowed you to single out an individual from a crowd, then that information, although it doesn't directly identify the individual, is still likely to qualify as personal data. So it should be apparent from that personal data is a pretty broad category of information, and for that reason you do tend to find it gets everywhere. So let's have a look now at the key responsibilities of organizations that are subject to GDPR. I should say that this is the kind of thing you could well do a day's training on without breaking a sweat, but these are some of the key ones here that you've got on the slide in front of you. So underlying the whole of the GDPR is this principle that you should be minimizing the personal data that you're using. So you shouldn't be collecting data on the off chance that you might want to use it in future. You should have a really clear idea about why you need the data, and you should make sure that the only data you're collecting and using is the data that you actually need in order to be able to carry out that purpose. There's also an underlying principle that once you've collected data for one particular purpose, you shouldn't start using it for a new purpose if that new purpose is incompatible with the original purpose. Now, the idea of whether a purpose is incompatible, again, is quite a broad one, but it often becomes clear once you start looking at what you told individuals when you collected the data and how you were talking about using it at that time. Which leads us on to making sure that there's a lawful basis for using the personal data. Now, the GDPR sets out a closed list of conditions and states that you have to be able to satisfy at least one of those conditions in order for your use of personal data to be lawful. Now, those conditions cover quite a wide range of circumstances, but the two that are particularly relevant in the context of fundraising are where the individual has given their consent to the use of the personal data, or where the use of the personal data is necessary in order to carry out a legitimate interest of the organization using it or of a third party, and that legitimate interest is not outweighed by the rights or freedoms of the individual. Now, if that all sounds a bit abstract, Tim's going to take us through what that means in practice shortly. It's also important to let individuals know how their data is going to be used. Again, one of the underlying principles in the legislation is this idea of transparency. So when you hear people talking about providing privacy notices or privacy statements, that's what they're talking about. Personal data, of course, has to be kept secure. Most breaches of the legislation, in fact, relate to security failures rather than any other sort of compliance failure. And that's a key thing that organizations need to be thinking about in practical terms. Alongside the idea of keeping personal data secure and data minimization is the concept of keeping data no longer than necessary. Again, you can only really judge what's necessary if you've got a really clear idea about why you need the data in the first place. But what you certainly shouldn't be doing is sitting on mountains of old data that you're not going to use anymore. Organizations that are transferring data out of the EU, so for example, data being transferred from the UK to the US, also need to make sure they're able to comply with the restrictions on transfers of data out of the European Union. Now, again, this is one of those situations where you have to be able to satisfy at least one of a number of fixed conditions in the legislation. But the ones that are usually relied on in the context of transfers to the US are where the individual has consented, and again, Tim's going to talk about what consent means in this context, or where an organization has put in place what are known as binding corporate rules. Those are rules that have been approved by a regulator in the EU, which govern how an organization is going to use personal data that's transferred out of the EU. And finally, organizations need to be able to comply with requests from individuals to exercise their rights under the law, and in particular, the right to access the data that that organization is holding. That's sometimes known as a data subject access request, and I expect we might talk a bit more about that later on in the session. So I'll pass you back now to Mark for the next bit.
Thank you, Oliver. So now I'm going to hand over to Tim, who is going to cover some more of the practicalities of how to actually apply what Oliver's just outlined in real life, in real live situations.
Thank you. If there's one piece of advice I can give you more than anything else, it's that complying with the GDPR is easier if you know what personal data you have. And I mean that in a practical sense. Think about the places in which you store data, the databases, the systems. If you have paper-based data, the filing cabinets, the more you can assess what you have and then from there why you have it, the easier almost everything else will become. So some kind of information audit, a popular approach in the UK is to focus on what are known as information assets, collections of data that are used for a specific purpose. The more you can get a sense of what of those things you have, the easier a lot of things will become. So absolutely the place to start is what have you got? Now, naturally following on from that, if you, as Oliver's already said, if you don't need the data anymore, you should absolutely dispose of it. I dealt with a client a few years ago who had a habit of storing things in a large shipping container sitting in a car park. Now, I doubt any of you are daft enough to have something of that type, but electronic versions of that, places where records or files are just put away and not looked at, are not uncommon. So once you know what you've got, make serious efforts to dispose of information genuinely that has no value, that does you no good, and set up some kind of retention schedule so that you can continue to dispose of information when it's genuinely no longer required. And the final element in terms of getting yourself set up for this is to think about whether there is information that is genuinely personal data which you can work on in an anonymized form. And when I say anonymized, what I mean is that the identity of the individuals has been definitively removed. It was personal data and you did know who the people were, but you've removed that and you cannot reverse it. And no one who will come into contact with the information will be able to put the identity back in. This isn't a loophole. Information that was personal data that has been anonymized is just genuinely outside the scope of the GDPR. And if you can make a decision that information is useful for research or for some other purpose, but you just don't need to know who the people are anymore, anonymization is a very useful tool to reduce the burden that GDPR might otherwise represent. Now, in terms of the legal basis for processing data, which Oliver's already referred to, the two, as we say, are the most crucial are consent and legitimate interest. So consent at the GDPR standard is not about somehow getting a tick in a box or something that you think you can rely on. Consent has to be freely given. A person has a genuine choice based on a clear understanding of what they're agreeing to, and they've unambiguously indicated that this is something that they want. So a tick in a box based on terms and conditions that they almost certainly haven't read won't pass muster, but a clear explanation of what they want followed by, a tick or a signature that indicates that they've read and understood something short and coherent, that's much more likely to be consent. You can also obtain consent verbally. The only danger with that is that GDPR is built on a principle of accountability, and that means you have to be able to demonstrate somehow that the consent was obtained. But if you can record that the fact that people have spoken to you, if you can actually record what they've said, these are two ways in which you can get evidence. Now, if you're not going to go for consent, that the likely other option is legitimate interest. Legitimate interest is, as Oliver's already described it, a series of things that need to be met. The legitimate interest itself is just something that benefits you. It doesn't have to be anything more than fundraising or informing people of what you're doing. It doesn't have to be in the public interest, but you have to show that the use of data is necessary. So there is no realistic alternative. There might be other ways of doing it, but they're clearly not as effective and not as reliable. Then you have to balance that against the rights and freedoms, the interests and expectations of the person or people whose data you're going to use. And crucially, you have to lay all this out. You have to show that the benefit to you or someone else outweighs the impact on that person. And a lot will depend on what you've actually told them in the first place. It's very difficult for something to be legitimate if it isn't clearly explained and known. So whether it's consent or legitimate interest, the third thing I've put on this slide underpins everything. You need to be transparent. You need to find simple, friendly, understandable language that will allow the person to know what it is that you're doing. If you're asking for consent, this will be a natural part of the process. It's here's what we plan to do, and do you agree? With legitimate interest, it isn't a natural part of the process. It's separate, and you need to look at these as two separate jobs that need to be achieved. But the greater you manage people's expectations with clear and simple explanations of what you're planning to do, the easier you will find these two things and a range of other things as well. Now, there are three issues which are very important in the context of fundraising. The first of which is something which has been a significant issue in the UK as well as in other places, but particularly in the UK because we've had a series of serious enforcement cases. Charities have been fined in the UK because of their use of techniques like profiling and wealth screening. But the perception that it's the techniques that are the problem is still very widespread, and it's incorrect. The reason why the Information Commissioner in the UK chose to enforce on wealth screening was the perceived lack of transparency. And at the same time, they also took action against the sharing of data between charities, which was without transparency. So there is no inherent stigma or problem with researching people to better understand them, to make better approaches to them. This is all totally legitimate processing, but it has to be based on a clear explanation. And I've spoken to fundraisers who say that wealth screening is inherently odd and difficult to explain, but all you need to do is look at organizations who are very transparent and very clear and very open about the fact that this is something they do and this is something they think their donors find useful. So it is worth exploring some of the enforcement that's happened so that you can see that it's the lack of transparency that is the problem, rather than this is a technique that is somehow banned. A second thing, which is much more related to the GDPR itself, is the notion of a power imbalance. And you won't find one section in the GDPR that definitively covers this. It's more of a thread that runs through the whole thing. The idea that where an organization has power over an individual, that limits what they can do in terms of using personal data, or at least pushes them in certain directions. It's harder for me to give consent to an organization who has power over me, who, if I say no, either can, or at least I think that they'll do something as a result of that. So if you believe that you have a power imbalance with a person, either that limits what you can do, and you have to be honest about whether you can actually get meaningful consent from them, or you need to put a lot of extra work into persuading the person that you're talking to that indeed they have a genuine free choice. There's a good example in terms of employees, where an employee might feel that to say no to their employer will have consequences in other scenarios. But if the employer clearly and simply explains that this is a genuine choice, that it won't have any knock-on effect anywhere else, then it's still quite possible to do that. But it's for the organisation to overcome power imbalances, to recognise them, and to make clear that they are not going to affect the person in terms of the decisions they're being asked to make. One thing you can do in particular to overcome power imbalances is to explain people's rights. People have a right, as Oliver's already said, to access their records. They have a right to object, to say that they don't want their data to be processed anymore. They also have a right to have their data deleted in certain situations, the so-called right to be forgotten. Now, objection and the right to be forgotten are two slightly different things. I might be content to let you keep evidence of our interactions, or I might decide, no, I don't want you to have my data at all. And the more people understand that they have choices, and those choices can be quite subtle, the more comfortable they will feel in terms of their interactions with you and any power imbalance there might be. One final thing to consider is that the effect of the GDPR on organisations outside Europe has not yet been tested. But it is worth considering that GDPR's reputation has spread around the world and is perceived by some to be the gold standard of data protection, something which I'm sure the EU are very keen on. But what you need to consider is, if it's perceived that you are processing data not to the standard that the GDPR asks for, if you're using data in a secretive or not really justified way, or in a way fundamentally that's unfair, which is one of the key principles of data protection, that use of data is fair. If that perception exists, even if the long arm of GDPR enforcement doesn't quite reach where you are, the reputational damage of being perceived not to be complying with its requirements is definitely something that you should weigh in the balance, and something you should take very seriously.
Thank you, Tim. So probably 2 or 3 years ago now, CAF had to embark on a big exercise to bring ourselves into compliance with GDPR. Obviously, we hold large amounts of data about people, and a lot of personal data that is held by CAF. And Fiona led the project that analysed the data that we have and brought us into compliance with GDPR before those regulations took effect. So Fiona is going to talk through a practical example of the sort of process that you can go through to analyse what you're doing and how you can do that in a GDPR compliant way.
Thanks, Mark. Yeah, so totally appreciate applying GDPR standards to all the things you've been doing up until this point is quite daunting and overwhelming. We've been through it in the last 2 or 3 years. We're still going through it now. It's a journey, and what we're doing is getting things right going forward as well. So building privacy by design into everything we do going forward. So part of that is in preparation for this webinar, the team come to me to go through what it is they're trying to do to try and achieve the goal in a compliant way, whilst maintaining GDPR standards. So this is kind of my train of thought that I would go through on this slide. First thing I would think about would be, can we do it? Do we have a legal basis? Is it tied back to our mission at CAF? Is it looking at what we want to achieve as an organisation? Does it complement that? And depending on what our legal basis is to do, so with contacting you individuals to invite you to this webinar, we fell upon legitimate interest as our legal basis. We felt it was in CAF's legitimate interest to reach out to you, and also in your legitimate interest. So the feedback we've had is that there's interest in this topic. So by providing this to you is something that you would be interested in. So then I look at with the team how we're keeping individuals informed. So what have we told you about what we're doing with your information? Have we linked to our privacy notice? Is it clear what your rights are? and just how reasonable we're being with your data. Like, is it clear and transparent? So we make sure any communications we send out to you are reviewed, and we think about that with data protection in mind. Then we'd look at how we're protecting your privacy. So we would only hold the data that we need about you to carry out this webinar. We would only share it with those who need to. So it's really restricted down to who needs access to it. It's not open for anyone to have and use. We only use it for the purpose we've said. And because we've used legitimate interest, we've given you the option to opt out of receiving those communications. You can unsubscribe on any emails that we would send to you. And then we would obviously apply standard security to those communications and to the data that we're holding at CAF about you. Then the fourth thing is who's responsible for the information. At CAF, we have data owners across the organisation. As the data protection officer, I work very closely with them and help them to apply the standards that are required. Ultimately, our trustees are responsible, but that gets delegated down. So our data owners are generally somebody who is senior enough to make decisions about the data that's being held and looked after, but also is close enough to the processes that are happening on the ground level. And they are held responsible and make sure that they've documented those activities, making sure data is only retained for as long as we need to, so we've got dates for it, who has access to it, and they're very much in control of the information that we have in their areas.
Thank you, Fiona. So we've now got some time for questions. If you'd like to submit any questions, then please do that. But the first question that I'd like to ask is, let's think of a scenario. So there's a university in the United States. They are planning some events in London next summer. They're inviting the president. The president of the university is coming over. They're going to host an exclusive evening with the president. How do they go through thinking through legitimate interest? You know, the evening itself isn't going to be a fundraiser with a direct ask for money, but it's keeping in contact with people, staying engaged with people, giving them an update on the university. Tim, can you talk us through maybe how they would, or the sorts of steps that would need to be taken in planning an event like that?
Okay. The first thing to say is, as I've mentioned before, the legitimate interest itself is quite straightforward. The interest is in informing people of an event that they will obviously be likely to take an interest in. So it being a legitimate interest is probably the easiest part of the test to apply. What you've then got to consider is, what method are you going to choose? What data are you going to use? What channels are you going to use to get in touch with the people that you want to invite? And just ask the question, is this necessary? Is there a better way to get in touch with them? Could you advertise it on Facebook, which would obviously open it up to a lot of people, but might not be the way you want to do it? Are you going to make personalized invitations based on expressions of interest? Are you going to send out an email? Whatever method you choose will be based on what you think is most effective. But you've then got to consider, is there a less intrusive, a more reasonable way of doing it? That will be a judgment. There's no science involved in this. You judge whether you think the way that you've chosen to contact people is the most appropriate, the most reasonable way of doing so. And then you look at, what will the impact be on the individuals, on their rights, on any freedoms that they might have. Have they specifically told you that they don't want to hear about events like this? So automatically you wouldn't contact those people. Most importantly, is this something that they would expect? Is this something that you've actually told them might happen? And automatically, if you've raised this expectation, it'll be easier to justify meeting it. Is there a possibility that people who are not invited would feel disappointed, would feel rejected? Again, these are all things that you can take into account. And bear in mind, I'm a humble data protection person. I don't know what kind of things the people you're dealing with will feel, what their expectations will be. So you need to feed into this the expertise of the law, but more importantly, the understanding of who these people are, what kind of relationship you've built with them, and all of that will go into a balancing test. The benefit to you, the effect on them, and as I say, this is not a formula. This is not scientific. Someone has to sign off on this and say, yes, I believe this is a legitimate and proportionate thing to do.
Thanks, Tim. So let's unpack this area of wealth screening a bit more, because obviously it's a very common thing for fundraisers to do, to make sure that they're interacting with the right people, the people who are going to be most appropriate to be developing their fundraising strategy with. Oliver, could you maybe unpack a bit about the sorts of considerations people need to be making, any real kind of traps to avoid falling into?
Yeah, so wealth screening has been one of these areas that's been under the spotlight, certainly over the last couple of years in the UK. And whilst it's true that wealth screening in itself isn't prohibited, you do need to think quite carefully about what information you're using when you're carrying out that sort of exercise and what you've told the individuals concerned. Now, one of the questions that you'll have at the outset if you're considering a wealth screening exercise is going to be, what information are you going to feed into the exercise and where did that information come from? Because the compliance implications of that exercise might vary quite a lot depending on where the information came from. So, for example, let's assume that you're only going to use information that the individuals concerned gave you voluntarily. For example, they might have given you information when they signed up to an alumni network. Now, if you're in a situation like that, your questions to ask yourselves are going to be, when they gave the information, what did they think we were going to do with it? And particularly, what did we tell them we were going to do with it? Now, it might be that when you collected that information in the context of an alumni network, you told people explicitly that one of the purposes of the network was to encourage people to support the institution financially, and that you plan to use that information to tailor your asks when you were coming to them and seeing if they'd like to support you. Now, if you've been very clear about that sort of thing, then you're going to have a relatively straightforward time being able to apply the legitimate interest test there when you're carrying out the exercise. By contrast, if you're going out and collecting information from other sources and the individuals aren't volunteering the information to you, then you might have a much harder time. So, for example, we know from past enforcement actions that there have been occasions when organizations have gone out and collected information from a variety of public registers and then used that information for wealth screening. So, for example, in the UK, there's a public register of companies, and that public register includes certain personal information about the directors of those companies. Those directors have to submit the information to the public register in order to comply with various legislation about the governance of companies. What some charities got caught out doing was going to sources like that, taking the data and then using it for wealth screening and fundraising purposes, when there was no way that those individuals could know that that's what the charities were going to do. And if you're thinking about using a public register, you've got to be asking yourself, why did the individual put that information there? And a lot of the time, for publicly accessible information like that, it isn't going to be for fundraising. So if you're thinking about using that information, you've got to be sure that you've been absolutely explicit with those individuals, that you have told them that you're going to go out and collect information like that. And of course, that's quite a tricky thing to do in practice if you don't already have an established relationship with the individuals. So these are all different factors that you need to take into account. Now, it's worth saying, of course, that some publicly accessible information might be information that individuals have volunteered. So, for example, if we think about something like a LinkedIn profile, all the information on the profile is information that that individual has chosen to put up there. But again, that doesn't necessarily mean that they've chosen to put it there so that you can use it for fundraising. If you're going to be looking at information like that, you need to be quite conscious of the nature of the information itself. So, for example, if you've got a profile where someone spends a lot of time talking about their philanthropy and their support for various charitable causes, you might be better placed to justify the use of that information for your fundraising. By contrast, if it's clear that someone only uses their profile for professional networking and they're not in the same sort of world as you in terms of their professional life, then it's going to be quite difficult to justify using that. And of course, it's not necessarily safe to assume that social media sites have told people that you might be using their data in the ways that you intend to. You need to look to yourself and take that responsibility on yourself.
Thanks, Oliver. So one of the questions that's come in is saying that well, their situation is most of the data they hold is in the US, and data isn't necessarily kept in the EU itself. But the questions that arise from that are, does GDPR still apply? And also, I suppose, could someone maybe also address the question of transferring data outside of the EU? Because a lot of people will perhaps gather data at events in London, and then that data is transferred outside the EU. So, Fiona, could you address, GDPR applies to data held in the US?
So depending on the citizens or where the citizens are from, that's where the GDPR would apply to that data, whether it's held in the US or wherever. So GDPR will apply. So the standards that you apply to all of your data is down to your organisation to decide. But the GDPR standards must apply to the data that is of EU citizens, regardless of where they are.
And what about this issue of transferring data out of the EU? What sort of considerations should people be making when they are doing that? Tim, do you want to tell that one?
The thing to think about is if you're going to be transferring information from the EU to somewhere else, there are two separate questions. The first is establishing the legality of that, and the second is establishing the security of that. So in terms of legality, there are a series of measures which are set out, as Oliver's already mentioned, some of them more suited to bulk transfers, like the binding corporate rules or standard contract clauses which have been produced, which have to be put into contracts using legal experience. You can't just pick a random lawyer. You need someone who's worked on international transfers before. But there are also some specific exemptions almost, like consent, which apply in specific situations. So you need to look at, are we going to be regularly transferring reasonably large amounts of information, in which case you're looking at things like standard contracts or binding corporate rules, or is this an ad hoc one-off transfer where one of the exemptions might actually apply and you can rely on it? But the other thing to say is, and it's an area that mustn't be played down, physically getting the data from one place to another is just as important a question, and it's especially a risk where you are doing something regularly. If I have to do something in a one-off way and I use my common sense and find the best and safest way that appears to be available to me, that's fine. But if something is going to happen regularly at the same intervals, maybe every year or even every month or every week, you really have to find the best and most secure way of doing that, because it's a much greater problem if you are consistently sending information in an insecure way than in one particular instance a person exercised their judgments and did so badly.
And do you consider email to be a secure method of communication or sending that data?
The thing about email is the email isn't just email. There is email, there is secure email, and what you need to look at is this sensitive information, either sensitive because it's financial or sensitive because it represents a special category which GDPR defines. So certainly in the UK, we are moving towards a position where sensitive data that is not sent encrypted is not being properly protected. You wouldn't get a definitive answer to that from the Commissioner right now, but we're very close to it. So email for name and address is probably okay, but if the information is sensitive, you really need to be looking at more secure options.
So Oliver, let's imagine a scenario where alumni have shared details about themselves through an alumni network, be that online, through an app, through email, however they've shared it. Can that be used? Does the fact that they've shared that data in that network give enough comfort that it's okay to contact them for fundraising purposes?
So again, this is another one of those situations where it's going to come down to what you told those alumni when they joined the network. And for that reason, if you're thinking about establishing a network or if you're making major changes to the way a network operates, it's worth doing that with one eye on the future, trying to anticipate ways that you might want to change the network in future. So if you've explicitly set the network up with the purpose of fundraising, then it's unlikely that any of your alumni are going to be surprised when you use the information that they've given you for that purpose. On the other hand, if you've set the network up and you've positioned it as a useful way for alumni to keep in touch with each other, perhaps to develop their careers and that sort of thing, then it may well be that they may be taken by surprise to find that you're now using their information for fundraising. Now, whether that's naive or not, I suppose, doesn't really matter from a legal sense. But that really highlights the importance of explaining to people what you're going to do with the information. And of course, that can raise some challenges where you've got long-established networks that perhaps might have originated for one particular purpose and are now sort of evolving into more sophisticated arrangements which serve a kind of mixture of purposes where you've got fundraising but also networking. But having said that, if you've got regular contact with alumni in a network, there's nothing to stop you explaining to them that you'd like to start using the network in a different way. Giving someone privacy information about how their data is going to be used, it's not a one-time thing. It's an ongoing obligation, and if you decide that you're going to start using data for a purpose which is different from the original purpose, once you've decided that the new purpose is not incompatible, you can show that there's a logical connection between the two, then at that stage, what you need to be looking at is refreshing your communications with those individuals to tell them about this new purpose. And at that stage, depending on which lawful basis you've selected as the basis for your processing, you might then be asking individuals whether they consent to that new purpose, if consent is the basis that you're going to rely on, or you might be offering those individuals a clear way of opting out if you're relying on the legitimate interest basis, because of course it's easier to demonstrate that you're meeting individuals' expectations if you've given them a way of telling you that they don't want you to do that thing.
Great, thank you. Fiona, do you think that US universities or some non-EU institutions should be considering things like holding data from EU-based alumni or people to whom GDPR applies? Should they be holding that data separately from the rest of the data they're holding?
I think, again, it depends on the organisation and what laws they have to comply with already, and what standards they apply to that data. If that already meets GDPR standards, I don't know enough about different US laws to make that assessment, but if they already align with GDPR standards, then there's no reason why you wouldn't have it all together. But if there is differences, then it's up to the organisation to decide as to whether to separate that out and apply the different standards to it. But there's obviously some challenges there for the organisation to consider.
Thank you. Last question, Tim. So you talked a bit earlier about the extraterritorial reach of GDPR. Does this really matter? Do non-EU institutions really need to be worried about getting in trouble with authorities over here, or is this something that can just be sort of not particularly worried about?
I would say, first of all, there is the reputational issue that, as I say, countries around the world, if they're looking at standards to create, the GDPR is likely to be what they're going to adopt. So there is this perception that this is the right way to do it, and there might be some reputational damage if you explicitly go against that. But I think more importantly, more practically, we're not just talking about monolithic institutions in the EU. Most of the regulatory authorities in the EU responsible for data protection are led by individuals, and some of those individuals have agendas, and even some countries have a feeling about the way GDPR should go. So there is a risk, not necessarily a huge risk, but there is a risk that some country in the EU or a group of countries in the EU will want to make a point. And if they want to make a point about the territorial reach of the GDPR, which is one of the big aspects of it that's different to what went before, they'll want to make that point by enforcing, and the obvious target of that enforcement will be the US. So I'm not going to place large sums of money on it, but I would bet you that at some point in the not too distant future, a European supervisory authority is going to take a look at an American organization and say, GDPR applies to you, and I'm going to prove it.
Great, thank you. All right, well, thank you very much to our panel. That's been a really interesting discussion, and I hope it's been helpful to everyone listening into the webinar. You can see on the screen now the contact details for our panelists. If you'd like to get in touch with any of them, I'm sure they're very happy to pick up any other questions or to help you with as you discover the implications of GDPR for your own activities in the EU. And our contact details at CAF are there as well. So feel free to follow up with us or anyone from the panel. The recording of this will be made available afterwards as well, if you'd like to either share it with colleagues or to re-go over some of it yourself. So those slides will be available, and we will distribute that via email as well, so that you can follow up on this, and we'll put it up on our website too. So yeah, thank you very much. I hope it's been useful, and please do get in touch if we can be of any help.